for Elevate.
Sorry.
Welcome to Copyrights for Startups. This is one of many sessions in a subject-focused series called Navigating IP. We're excited to run this session today. We're hoping you gain valuable insights and in the process also help us continue to develop and improve our educational offerings for startups. Before we give you a short breakdown of the program and introduce you to our speaker, we'd like to play our Communitech land acknowledgement.
Sorry. Communitech acknowledges that our hubs are situated on the Haldimand Tract, land that was granted to the Haudenosaunee of the Six Nations of the Grand River, and are within the traditional territory of the neutral Anishinaabe and Haudenosaunee peoples. As participants in today's event, we are coming together from many different places. We encourage you to learn about and acknowledge the land from which you participate. We will never stop fostering an anti-racist environment to create a place and space where everyone is free to be their whole selves. Our commitment to building a community rooted in inclusion and equity will never waver, and it will mean listening and learning as we go. Everyone on our team and within our community receives the same respect and opportunity regardless of age, ethnicity, gender, culture, identity, beliefs, or language.
All right, so just to give you a quick breakdown of Elevate IP, Elevate IP is a federally funded program designed to help Canadian startups understand, manage, and leverage their intellectual property. Communitech, along with our partners North Forge and Invest Ottawa, deliver Elevate IP services and supports to startups in Ontario, Manitoba, and Saskatchewan. A few eligibility criteria here. You must be headquartered in Ontario, Manitoba, or Saskatchewan. You must be CCPC, have less than 500 employees, and the IP protections to be acquired must be owned by the startup and not the individual. We have three types of tiers in our Elevate IP program. The first is awareness and education, and this is for startups new to IP education and gives you a foundational knowledge for early stage startups. Then we have developing IP strategies, and this is for startups in need of an IP strategy where they're connected with a service provider and work towards developing their IP strategy. And then third is implementing IP strategies where they also work with a service provider of their choice. And this is for startups that are implementation ready in their work. We have some post-session information here. So we will be sending out an email with a feedback survey. So please do take a few minutes to complete this. By providing us with your feedback, you're really helping us to ensure that the content of these sessions meet the needs of startups going forward. For any Elevate IP updates, please register a profile on our Elevate IP portal. And you will have an update of all of our Tier 1 offerings for education on there, as well as an opportunity to apply for our Tier 2 and Tier 3. So now to introduce you to our speaker. Jillian Burrell joined PCK in 2019 after graduating Osgoode Hall Law School. Her experience includes interning in patent litigation at an international pharmaceutical company and participating in the International Patent Drafting Competition. Active in the Innovation Clinic at Osgoode, she provided IP advice to startups and conducted patent and trademark searches. Now she focuses on drafting and prosecuting patent applications, performing patentability searches, and contributing to the firm's blog. Jillian was called to the bar in 2020 and became a registered Canadian patent agent in 2024. PCK is also one of our registered service providers if you choose to apply for the Tier 2 or Tier 3 offerings of developing strategies or implementing strategies. So thanks very much, everyone. The slides will be available after the session, and the session is also being recorded. We're happy to, and Jillian is happy to take any questions during the session, and you can either unmute or put them in the chat and we'll monitor that. Over to you, Jillian.
Thank you for the introduction, Rochelle. Although my biography did focus on patents, I do cover all areas of intellectual property in my practice. Copyright, as you'll understand from this presentation, is a very small area of IP, but it's important to understand how it fits into the big picture and how it overlaps with other areas of patents and trademarks. So before we get started on the presentation, it wouldn't be a legal presentation if we didn't start with a disclaimer. This presentation is for information purposes only, and it's important you remember that, and this is not considered legal advice. Most legal issues are very contextual and fact specific, so if you have any questions about your particular situation, it would be best to have a one-on-one conversation with an IP professional. Please also note that I'm a Canadian lawyer and my presentation is going to focus on Canadian law. Copyright law is very different in different countries, and what I teach in this presentation may not be relevant outside of Canada. To give you an overview of where we're going today, I'm going to start by talking about IP in general so that you have an idea of where IP fits in, of an idea of where copyright fits into the other areas of IP and how it differs from patents, trademarks, and designs. Then we're going to cover some basics about what copyright is and what it can protect. And then I will give you some practical tips on how to protect the copyright that your startup owns. On the flip side of protecting your own copyright, we also want to be respectful of other people's copyright rights. So we're going to be talking about navigating copyright infringement. Towards the end, you will implement everything you've learned in this presentation, and we're going to develop together an IP strategy for a hypothetical startup. Lastly, I'm going to leave you with 4 main takeaways, and if you remember nothing else from this presentation, I want you to remember the 4 takeaways at the end. So before we start covering each area of IP, I want you to reframe your perspective on IP in general. Startups who come to me looking for IP strategy advice, they often think of IP just as a checkbox that they need to tick off in order to please their investors, and they don't really think about how their IP strategy fits in with their business strategy. So they're not getting the most they could get out of the IP. Um, on the other hand, some startups come to me and they have a really great idea for a patent or copyright registration that they want to file, but they haven't really figured out how to monetize that IP. So instead of thinking about IP in either of those two ways, I want you to think of it first as a business tool. It's a tool for furthering your business objectives. So when you map out an IP strategy, you actually want to start with what your business objective is and then work backwards from that to figure out how IP can help you further that goal. And as part of that analysis, what you need to do is identify your point of difference. In other words, what is it that makes your business unique in the industry that you're operating in? What makes consumers choose you over your competitor's product or service? And the point of business might be that your product or service is cheaper than what your competitors are offering. Or maybe you have a feature that your competitors can't offer. Or maybe your product just works faster or smoother than your competitor products. Once you've identified this point of business, we're going to ask, how can IP help protect that point of difference? IP works by preventing competition. It prevents competitors from copying exactly what you're doing. So if you use a variety of IP tools, including copyright, you can form these fence posts that sort of block out your competitors from the little area of the marketplace that you are operating in. And this can help maintain your uniqueness over time. When you use IP in this way as a business tool, it actually becomes a very valuable corporate asset. In fact, for many corporations, it's their most valuable asset. Even though it's intangible, meaning you can't hold it in your hands, it's not a manufacturing facility, it's not an inventory of products, it's an idea, really. Nonetheless, it's still listed in your financial statements along with physical assets. In fact, if you look at the most successful corporations in the US, the top 15 corporations, intangible assets like intellectual property form 93% of the enterprise value. And looking worldwide, there is $74 trillion worth of intangible assets held worldwide. And the reason it's so valuable is because IP has this incredible power to prevent competitors from directly competing with you. So IP has a lot of different areas, and we'll just skim through them quickly so you can see how copyright is different from the other areas. Copyright is traditionally associated with artistic endeavors like music, books, paintings. But today in a modern world, we recognize that copyright applies to a lot of different creative endeavors, which includes software code, product documentation, and product packaging. In contrast to that, designs, which are also called industrial designs or design patents, designs protect the ornamental features of a manufactured object. For example, the iPhone case looks different from the Samsung case, and that doesn't affect the way the iPhone works. It's purely ornamental. We use design patents to protect that. Similarly, the hubcap of a car might be very distinct, but it doesn't affect how it operates. Trade secrets can protect anything that is confidential within your organization. This could include a wide variety of things, including product know-how or customer phone lists. Trademarks protect aspects of your brand, such as your logo. And here are two very well-known logos that could be protected with trademarks. The last area of intellectual property is patents, which covers inventions, and these protect the way something works. For example, a new machine, a composition of matter, or even a novel process. So today we're going to focus on copyright. To give you a very simple definition of what copyright is, it's a right to prevent others from copying or using original works during the creator's lifetime and for 70 years after. Now that's a lot in one sentence, so we're going to break it down into chunks. The first section says it's a right to prevent others from doing something. So it's not a right for you to use your own creation. And that's a really subtle but important distinction. There might actually be a lot of reasons why you can't use something that you created. For example, you may have created something that infringes on someone else's intellectual property rights, so you can't use it. But because you added something creative to what you created, you can prevent others from copying it. The next chunk of this sentence says copying or using. So copyright, it's in the name, it is concerned with copying, meaning you had reference to an original piece of art and then you copied it. It does not protect against independent creation. So in a hypothetical example, maybe you have 1,000 monkeys and they're all typing on typewriters. And by chance, eventually in 1,000 years, they're going to type out all 7 Harry Potter books. And that's not going to be copyright infringement because it happened independently of the original books. The monkeys weren't copying from the original Harry Potter books, so J.K. Rowling can't assert her copyright against the monkeys. Copying doesn't have to be exact. Even if someone just copies a substantial part of the work, in terms of quantity or in terms of quality, it can still be considered copyright infringement. So to give you another silly example, if you copy 2/3 of a Star Wars movie, that would probably still be copyright infringement. But if you just copy a single sentence from the screenplay, that's less likely to be copyright infringement. Copying also includes copying in a modern digital world. So if you download a movie from the internet, you're creating a new digital copy on your computer, and that would be captured by copyright. I've also written using in there to consider that sometimes you can violate someone's copyright without creating a copy by performing or distributing a protected work. So, for example, if you've hired out a venue and you want to play some music from Spotify for all of the guests who've come to the event, that would be a copyright infringement unless you got permission from the owner of that copyright. What copyright protects is an original work. And work is a very open-ended term. It is used to capture all sorts of creations. As I mentioned at the beginning of this presentation, it can protect artworks and music, but it also can protect things like software. The only real requirement for a work is that it has to be original, meaning it must be created by you and not copied from someone else. The work must be fixed as well in a tangible form. This means it has to be written down, recorded, or otherwise captured in a physical medium. So if you have composed a song in your head, but you haven't written it down, you haven't recorded it onto tape, then that's not going to be protectable by copyright. Lastly, the work does not extend to cover an idea. It's only limited to the particular expression of an idea. So if you write a science fiction book about mutants, you could stop someone from copying the story and the characters, but you're not going to own the underlying idea of mutants. And anyone can write their own science fiction book about mutants. Copyright doesn't last forever. It has a limited term. So it lasts for 70 years after the death of the creator, or 70 years specifically after the calendar year in which the creator died. And at that point, once the copyright expires, anyone can copy or use the work freely. And the reason we have this limitation is that we want to free up old works so that they can be reused and inspire future creators. There are a number of exceptions, though, to the life plus 70 rule, and determining when copyright expires is not a simple exercise. For example, in the past, the term was limited to life plus 50, and any copyright that expired before January 1st, 2023, when the new rule came into effect, that's going to remain expired, even if it's been less than 70 years since the author died. So what can you actually protect in your company using copyright? Well, let's start with what you can't protect. As I mentioned, you can't protect ideas. You can't protect business methods either. So if you have a new accounting method or something like that, that's not protectable by copyright. You can't protect original works. It has to be original. So what can you protect? Well, traditionally, copyright is associated with artistic works like images, literature, videos, photographs, architecture, choreography. But in a modern world, we use it more broadly to protect anything where someone has put a lot of creativity into the work. So we also have product packaging. There's a lot of graphic elements and design elements that go into the shape and the look and the colors on a product package. Website design, similarly, the choice of the fonts, the layout, all the graphics that go into that, that's protected by copyright. A user interface and the animations in a user interface can be protected by copyright. Software code as well, surprisingly. It's written down. There's a lot of different ways you could implement sort of the same algorithms, and the specific one that you use to implement software could be protected by copyright. Organized data, because there's a lot of creativity in what categories you're using and how you're organizing that data, that's protected by copyright. And finally, product documentation. So user manuals and other leaflets that are associated with products can be protected by copyright. While copyright is distinct from other areas of IP, there's actually an overlap. And a comprehensive IP strategy is going to capitalize on that overlap so that areas that are particularly important to your product and your services are going to be protected by at least two different areas of IP. So with respect to patents, you can protect technology and software with patents because patents protect innovations and processes, but software can also involve copyright. So the code itself might be protected by copyright, whereas the underlying technology and the algorithms can be protected with patents. In a multimedia product such as a video game, you might have overlapping protection there too. So the code and the artistic elements of the video game could be protected by copyright, but you might use patents to protect the hardware for like a VR headset. In the area of trademarks, a logo is a great example of something that can be protected both with copyright and trademarks. So the graphic elements and the colors used, those are creative elements that can be protected by copyright. But at the same time, you might want to register a trademark to protect the consumer's recognition of that logo as a brand identifier. Also in product packaging, you can use both trademarks and copyright to protect a product packaging. The unique designs in the product packaging can be both copyrighted and registered as a trademark. Trade secrets, so that's confidential information. You can protect that as a trade secret. So any formulas or proprietary processes, documentations that you keep within this company can be trade secrets, but there's also creative elements in there that can be protected by copyright. Similarly, software can be protected as a trade secret. So if you've got it on a back-end server and you're not releasing that to the public, it's considered a trade secret. But you can also protect that source code with copyright at the same time. As long as it's not publicly disclosed, it can be considered a trade secret. Industrial designs protect the visual elements of objects. So you could protect the design of a chair, for example, with a design patent, but copyright could protect a sketch of the chair that was used in the designing of the chair. You really want to focus on the overlap between these areas of IP, particularly for commercially valuable products and services. The more protections you have in place, the more you're going to be deterring your competitors from copying what you're doing, and this protects your point of difference, which we discussed is the key part of your IP strategy. So now I'm going to move into some practical tips for protecting your copyright. After you've identified it, you want to make sure that you own it. And this is the most important step of the copyright strategy, because the person who created the copyright is by default the owner, not the corporation. So unless you've agreed to it in writing to transfer the rights from whoever created it to the corporation, you might not actually own your own IP. Establishing clear IP ownership from the start is very simple and efficient, and yet it can prevent costly and complex legal issues later. Despite this, despite how easy it is to effect, it's very common for startups to focus on rapid growth and cut corners when it comes to IP management, including establishing ownership over their copyright. It's a very common pitfall that we see. And as I said, it can lead to very costly disputes later and undermine the valuation of your company. So to avoid these pitfalls, what you can do is, first of all, make sure that you and your employees aren't integrating someone else's copyrighted materials into your product. If your materials involve third-party copyright, you're sort of inviting a copyright dispute later on, which could be costly and time-consuming to untangle. So to avoid this, you want to conduct regular audits and also provide training to each of your team members so that they understand what copyright is and how to avoid infringing other people's copyright. Secondly, you want to keep very detailed records of the copyright that you own and any copyright that you're incorporating into your product. So make sure that you can prove ownership, which will allow you to defend against allegations of infringement and also enforce your own copyright going forward. So maintain records of who created what, and when. You can, for software and other large works, you can store that in a data storage provider such as Iron Mountain. That's a great way to keep track of your versions in a software program. And then finally, you want to control ownership of your copyrighted materials using IP clauses. So every agreement that you have with an individual inside and outside of your company needs to have an IP clause to clarify that the IP that they're contributing, including their copyright, is transferred to the corporation so that you can actually own the product and the service that you're investing in developing. Let's look at what should be included in those IP clauses. First of all, it needs to be an agreement to assign any of the IP generated to the corporation. So this will include any inventions, designs, software, and creative works developed through the course of their work for the corporation. The second key element of an IP clause is confidentiality. So you may want to include an obligation on the vendor or employee to maintain confidentiality of any business information that is not already publicly disclosed. And then thirdly, you want to include a waiver of moral rights. Moral rights is another part of the rights given to the creator through copyright. So the creator has the right to be attributed as the author, and also has the sole right to modify a creative work. So you don't want these limitations hanging on to aspects of your product or your service that you're developing, because it really limits the flexibility in how you can use works that are contributed to your company. But by waiving the moral right, which has to be done in writing, the creator allows the company to use, modify, and adapt the copyright without needing further permission from the creator. If you have all these three elements in an IP assignment, then you're going to ensure that the corporation retains full control and protection over its copyright, which will safeguard your assets and maintain your competitive advantage. Another aspect of protecting copyright is just deterring others from copying. It helps ensure that your copyright remains secure and it preserves the value of the copyright. You can do these proactively to help deter your competitors from infringing on your copyright. The first step is to limit distribution. Be selective with who you're sharing materials with inside your company. We talked about publicly disclosing works earlier. If you can, keep it as a trade secret, meaning keep it confidential within your company. If you have to share outside of your company, make sure there's a confidentiality clause in an agreement with that vendor or contractor who's outside your company. Or you could use a non-disclosure agreement or an NDA to help discourage someone from misusing information that you share with them. Even within your company, you can also limit circulation of materials and information. So if you just put your information into the firm drive that you have on Google, but you don't control the access, then anyone within your company might be able to access that. And if it's not necessary for every single employee to access that information, then don't limit the access using passwords or restrict the sharing permissions on that folder. The second step you can use is digital protection measures. So if you go to a site like istockphoto.com, which distributes stock photos, you'll see that every photograph is watermarked, and this prevents someone from actually using a photograph that's copied from the website. You might also want to embed ownership information into the file, into that metadata, which makes it harder for someone else to claim it as their own. And then you can also use encryption to ensure that only people with the correct key can access information. And the last point I've got on there is to mark materials with copyright notices. You might see in the bottom right-hand corner of my slide that I have a copyright notice on every slide. And the purpose of this is to warn other people that my company, Perry and Courier, or PCK, owns the copyright in this presentation. So you can do this as well. What you need is the copyright symbol with a C in the circle, the year, and the name of your corporation. You can also write all rights reserved, something to that effect, just to notify people that you're aware of your rights and that they should be aware of who owns the copyright in that material. The last aspect of protecting your copyright, which I'm going to talk about, is registering copyright. And contrary to popular belief, this is really the least important aspect of a copyright policy. So registering your copyright is another way to notify the public of your rights, but is absolutely not required, and copyright exists whether or not the copyright has been registered. And that's why I left it to last. Um, each country has its own system for registering copyright. I'm going to focus on Canada and the US. Those are probably the biggest markets for you anyways. In Canada, registration provides the presumption of ownership and presumption of the date of creation. So you can use that when you go to a court and try to enforce your copyright against someone else who's infringing. In Canada, the copyright certificate is issued automatically without any substantive review from the Copyright Office. In fact, the Copyright Office doesn't even accept a copy of your work. They're not going to ensure or verify that your work is copyrightable. They're just providing a certificate that says that you are the presumed owner of a work with a particular title. In the US, a similar method of registration exists, except that you can actually submit your work to the United States Copyright Office. Registration in the United States is similarly not required unless you want to enforce the right. So if you are intending to go to the courts and accuse someone of copying your works, you will have to register right before. In both Canada and the US, you can register through a very simple online portal, and I'm going to show you now what that portal looks like. Here's the portal for registering copyright in Canada. As you can see, it's really quite simple. We've got a title of the work, and then in that right-hand sidebar, you can see the other categories of information that you need to put in. You need to put in the category of work, like what type of work is it? Is it a photograph? Is it a piece of literature? The publication date, if applicable, the owner, so that's probably going to be the name of your startup, the author, so who is it who actually created the work, a declaration that the information is all correct, and then the last two categories are optional, but if you have a lawyer apply for the copyright on your behalf, then they'll be filling out that agent section of the portal. The fee for applying for a copyright registration in Canada is 63 Canadian dollars. And as I mentioned before, there's no way to actually submit a copy of the work, only the titles and details about the work. And then the Copyright Office is going to issue a copyright certificate within like 1 to 2 weeks. It's pretty quick. In the US, we have a very similar sort of portal where you're going to input all of the biographical details about the copyright registration. The main difference here is that you can upload a copy of the work in the US, which makes it a little bit more complicated to apply for as compared to Canada. The standard registration fee is 65 USD. Unlike trademarks, there's not actually very many advantages to filing a copyright registration early. The author or the corporation will own copyright as soon as the work has been created. It's not dependent on the registration. Registration of copyright only provides you with a presumption of ownership. So for that reason, you want to be really selective about what kind of works you're registering for copyright. And here are the criteria I want you to focus on. First of all, contentious works. And this is the only area that I actually recommend to my clients to file a copyright registration for. If you are contemplating a copyright dispute, then do file a registration as soon as possible in the relevant jurisdictions. So a contentious work might be a work for which the ownership is in question, if there's some disputes about that, or if you suspect that maybe someone has copied your work. This is really common when an employee leaves your company and then starts up their own competing business. You might be worrying what kind of information they have taken with you. And so if you're worried about that and you want to assert ownership over the information they've taken with them, then apply right away for a copyright registration on any relevant works. As a startup, though, you probably haven't reached that stage in your business, so there might not be anything for you to register right now. Once you build up a legal budget for protecting IP, you might want to consider these other areas to protect. The first is published works. So I would prioritize applying for copyright registration on anything that's been disclosed to the public, whereas information that's kept as a trade secret, meaning it's confidential within your company, that's not going to be much of a priority for registering at the Copyright Office. Another priority would be commercially valuable works. So you might register copyright in a logo because it's got a lot of commercial value and you're putting it on all of your products, on all of your packaging and your website. It's everywhere. It's out for the public. So because of the commercial value, that might be a higher priority for registering. And then lastly, you should consider whether this is a major work. Does it represent 2 years of effort that took you to write a novel, or is this just a single edition of a magazine? So you can prioritize a lot and figure out where to put your budget for copyright. On the flip side of protecting your own copyright, you also want to consider the rights of other people, so that you can avoid copyright disputes. Copyright infringement occurs when someone copies an original work or a substantial portion of an original work without permission. Determining whether copying counts as copyright infringement depends on the very specific details of each case. It's very contextual and fact specific, meaning that every situation is unique and has to be evaluated individually. For that reason, it can be really costly to resolve copyright disputes. And when a client comes to me and asks, am I committing copyright infringement, or has someone infringed my copyright? It's very difficult for me to give them a straight answer, and I'm more likely to tell them probably or unlikely, because there's so many facts that change the scenario. One common misconception that I see from people about copyright is that they think because they've transformed a work, because they've made it their own, that it's not copyright infringement. And that's really not true in a lot of scenarios. If you add creativity in a copyrighted work, well, copyright law isn't really concerned about what you've added to it. What they're concerned about is what you've copied, regardless of what you've added. So if a substantial part of the original work is still recognizable in something you've copied, then it could still be considered copyright infringement. The key question, again, is whether a substantial portion of the original work has been taken, regardless of anything that's been added. Another misconception is that, well, I found a photograph online and there was no copyright notification. I couldn't tell who was the photographer, so I didn't know who owned it. So I just thought it was free to use. That's a common misconception. And just because there's no copyright notice or just because there's no copyright registration doesn't mean that copyright exists. Doesn't mean that copyright doesn't exist. The copyright exists in a work because someone created it, regardless of whether they put a notice or a registration up for public notice function. Another area that's really complex and there's a lot of misconception around is fair dealing. And that's a Canadian concept. The US equivalent of fair dealing is fair use. So this is a defense against copyright infringement. But the court is only going to consider fair dealing or fair use after they've already found you to have infringed copyright. So it's best just to stay away from that entire area altogether and avoid copyright infringement to begin with. You should also consider that fair dealing is only available in very limited circumstances, and it very rarely applies to commercial works. It usually applies to journalists, educators, areas that are not necessarily strictly for profit. If you do want to use someone else's work, you can go to open source materials. Copyleft is a trend towards open source materials that we've seen in the last few years. A lot of people are distributing materials under open source licenses, such as GNU or Creative Commons. So you might have seen materials distributed online under these licenses. If you are using any of these materials, be sure to keep detailed records of what you're using. Keep a copy of the license as well. Keep details about when you acquired it and what it looked like when you acquired it, so that if you do need to defend against an allegation of infringement in the future, you have accurate records to back you up. Do be careful of the terms and conditions which are stipulated in the license to make sure that the use that you are planning to use the material for falls under the license. And if you ever have any doubts about whether you can use a material or not, be sure to consult a copyright lawyer. Another way to obtain materials with permission is to obtain a license for the work. And that can be really daunting if, for example, you need to get permissions from 100 different artists to use 100 different songs in a playlist. So if you have ever rented out a venue, they probably asked you to pay a SOCAN fee in order to play music. So SOCAN is a collective society, meaning that it distributes licensing fees to a number of artists. So you only have to pay one fee to SOCAN, and then they're going to distribute it to the appropriate artists. And similar collective societies exist for other areas of copyrighted materials. Now it is time for us to put into practice everything you've learned today about protecting copyright. What we're going to do is develop an IP strategy for a fictional startup. Here's my fictional startup that I came up with. You're going to imagine that you own a startup called Tasty Tunes, which creates music and videos for cooking tutorials. Your content is unique because it combines catching material with easy to follow recipes. We're going to develop a copyright strategy for Tasty Tunes. First of all, what copyright do you think Tasty Tunes owns? And if you have an answer for that, I'd love for you to put it in the chat or raise your hand so we can start discussing that. I'll give you a minute or so to think about what copyright Tasty Tunes might own. Try to be as comprehensive as you can. Consider not just the obvious ones, but all of the copyright. We talked about different areas before, like software and product packaging and things like that. So what kind of copyright does Tasty Tunes own? Okay, we've got logo, name, and music. Yeah, that's really interesting. So the logo here, which I did use ChatGPT to generate, is it's got a lot of graphic elements in it. All of these artistic elements might be protectable by copyright if we hadn't used ChatGPT to generate it. So that's a great one. The name itself, Tasty Tunes, is actually going to be kind of too short to protect with copyright. We need something a little bit more substantial before we can implement copyright to protect it. So the name alone, probably not, but the layout for the name, the artistic elements that went into the font and the color and the layout of the name and the logo could be protectable by copyright. The music, definitely. There's a lot of creativity that goes into creating music, so probably the music would be copyrightable. Someone else said the trademark, and I think you're going to have to specify which aspects of the trademark. So specifically, like the graphic elements in the design would be protectable by copyright. Rob's asked, does Tasty Tunes Inc. work? So could you protect Tasty Tunes Inc. with copyright? Again, that's going to be too short, probably. Someone did try to protect once a name of a company. I think it was like Verizon or something similar to that because it was an entirely new word that was made up. The court said that's too short. So you're going to need at least a full sentence in order to protect with copyright. But the name can be protected with trademark. So it's not unprotected by IP. It's just copyright's not ideal for that. Trade secret of combining music for specific applications. Yeah, if you have some sort of formula that you're using in-house that works to create products. For example, you have different genres of music for different types of cooking, like baking has a certain genre and then frying things has another genre of music. Maybe that's something you have a written policy inside your firm. You don't want to necessarily publish that. It might be inferable though from someone else looking at your videos, but you could certainly protect the that policy that you have written down because it's a piece of literature essentially if you have a document. But if it's not written down, it doesn't meet the requirements of fixation. So I mentioned earlier at the presentation that the work has to be fixed into a tangible form. So it has to be written down, recorded, or otherwise put down. If it's just something that you talk about within your company, it's not written down, that's not going to be protectable. Okay, so the next part of the copyright strategy is how can Tasty Tunes protect its copyright? So what steps are you actually going to take to protect the logo and the music and other elements? I should have mentioned that probably Tasty Tunes owns copyright in the videos themselves. Those are artistic works. If they've written any recipes down and published those on the website, then the layout and the particular words that they use to describe the recipe, that could be copyrightable. The layout of their website too, all the materials on their website and any marketing materials could be copyrightable. So what steps is Tasty Tunes going to take to protect the copyright? And please, again, either raise your hand or type an answer into the chat. Yeah, you could certainly register the trademark. I wasn't thinking of that because I'm trying to focus on the copyright, but definitely register the trademark in the logo and the name itself alone. So you can have a trademark registration for the word mark, meaning just the word Tasty Tunes, and you can have a trademark registration on this design, including the graphic elements and the fonts and the colors used. Would you register copyright in the logo? Yeah, you could definitely do that. As I mentioned earlier, it's probably not a priority unless you think someone's going to copy it or there's another dispute brewing about copyright registration. Certainly at your stage of a startup for Tasty Tunes, it might not be a priority right now. Does anyone have any other ideas of what steps, practical measures that Tasty Tunes can take to protect its copyright? So I've got a question here. Is there a need to protect the name since the corporation name is protected when you incorporate? that would be an area of trademark law rather than copyright law. But yes, you definitely need to protect your corporation name with a trademark, not just with the corporate registration. Corporate registration does not protect against someone else using the same name, Tasty Tunes, to promote their business. Yes, a copyright notice. That would be a great way to protect Tasty Tunes as well. So Tasty Tunes might want to put the copyright notice on YouTube, like with every video that they post, they should have a copyright notification on that. And you can put it on the video itself as well as the video description. They might want to use other methods of protecting the videos. So for example, they could have a watermark on the video so that if anyone tries to copy it, there'll still be a watermark saying Tasty Tunes throughout the video. Other methods that I'm looking for are, the most important one is IP clause. I absolutely need Tasty Tunes to have an IP clause in every agreement. So every employee who's working on the video, every social media manager, the composer, the videographer, any actors in the video, the animators, logo designer, every single person who touches the content that Tasty Tunes creates needs an IP clause in their agreement. And that is the only way that we can ensure that Tasty Tunes actually owns its videos and its website and its marketing materials. So that's the number one step that they need to take. We already talked about copyright notices. The third one that I have is keep detailed records. So Tasty Tunes needs to be keeping records of who worked on which videos and when it was published, what it looked like when it was published, and any subsequent changes to the videos that happened afterwards. And another step they could take is to avoid contamination by educating their team on the copyright rules to make sure that, for example, their composer isn't replicating a song created by Taylor Swift, or make sure that their video editor isn't integrating video clips from a video that was created by someone else. I see we've got another question. So could someone claim copyright or trademark? Could someone else claim ownership after they've been copying your copyright or trademark? So I'm going to limit this to copyright because we're trying to limit ourselves to copyright. So if someone else has, for example, copied Tasty Tunes video and put it onto their own YouTube, could they claim that they own the copyright in that video? I mean, they could claim whatever they want, but they don't own the copyright. What's important though is for Tasty Tunes to be able to prove that they were in fact the original owners and the original creators. And if they don't have detailed records, for example, they later deleted their own YouTube posting of that video, and they don't have any internal records of creating the video, it's going to be really hard for Tasty Tunes to prove that someone else copied their video. I think I'm going to move away from Tasty Tunes now and just open it up for questions, because it seems like a lot of you have questions about generally IP and copyright. So the next question is, can someone make IP protection in Canada, for example, get protected in China or the US? So I'm not familiar with the copyright regime in China, and I have limited experience with the US. But generally each country is going to have their own rules for obtaining a copyright registration and recognizing copyright. If you want to ensure that your right is protected in other countries outside of Canada, then you're going to need to consult a lawyer who is registered and licensed to practice in that company. In that country.
There's a few other questions in the chat. There's one about patents. How are specific recipes of chemical combinations for useful products patented? And they're specifically wondering if broad combinations of products themselves are patentable, or if it is the unique ratios. It's quite a specific question about patents.
Yeah. So in patents, the requirements for obtaining a patent are that it needs to be a certain category that we recognize as an invention that we patent. So a machine, a manufacturer, a process, or a composition of matter. So composition of matter is something that we can protect with patents. You're asking whether specific combinations are patentable. Or if unique ratios are required to be patentable. And the answer is both. The requirement in that regard is that it needs to be new and non-obvious. So it has to be a new combination and it has to be not obvious. So if you have an existing adhesive and you've modified that and added a new ingredient to the adhesive, that could be patentable as long as what you've added isn't just like an obvious addition, like, oh, I added water. Well, I mean, a lot of compositions have water in it, so that might not be inventive. But if you can show like nobody else has added water before to this adhesive, it's really interesting. People thought you couldn't add water to adhesives. Then we can sort of establish a story and draft a patent that's going to allow you to protect that new adhesive composition.
Okay, and what about if there's like basically I've there's a specific thing I'm wondering about. I had read some research about a broad combination of chemicals to produce a resin, and then I've expanded upon that research. I'm not sure if the original combination has been patented already, and my research has expanded beyond this initial research. I'm wondering at what point does it become a novel idea, and if that broad combination itself would be patentable in a way that prevents other people from using that, say, just chemical A plus chemical B. Can you prevent other people from mixing those two chemicals?
Yeah, so you can prevent someone from using that combination if you've been granted a patent, right? And it takes a long time to get a patent approved. From the application date to a grant, it can usually take about 2 to 5 years. Sometimes it can even take longer. And you're going to be arguing with the patent office that this combination of A plus B is novel and also obvious. You mentioned that sometimes there's prior art, meaning someone else might have already published a similar composition. So with respect to that composition, you're going to be worried about two things. You might be worried about, first of all, infringement. Am I infringing their patent rights? And that will depend on whether they've applied for a patent and whether it was granted by the patent office as being new and non-obvious. And if you've added something, where they've got a patent for A plus B and you've added C, well, you're still using A and B. And if that's covered in their patent, that might be infringement. And then the second part of the question, so the first was infringement. The second is my combination patentable? So if you've got A plus B, that's going to sort of depend on what's out there already. Was it obvious to add C to the combination that already has A and B? And that's really, a very fact-specific question, and it can depend on the opinion of someone who's skilled in the field, which might be someone like yourself, who's an inventor, who knows a lot about adhesives, and already knows about what's generally known in the field, and what's published in journal articles, and talked about at conferences, what the knowledge is of the person skilled in the field of adhesives. So let's see, I think we got a copyright question up next. What are the consequences of not updating the year on a copyright marking? I wouldn't say it's necessarily a big mistake. I would put the year that it was created, and then if you make any updates, continue to update that year. It's part of the record keeping process, and it's just one of many tools that you can use to prove to a court if you have to enforce your copyright at court, to prove to them that you had created that copyright. So not necessarily a deal killer when it comes to enforcing copyright.
Great. Were there any more questions at all?
So I've got another question in there about multiple authors creating source code for a startup. So if there's multiple creators who have contributed to something that's protected by copyright, when does the copyright expire? And I'm actually going to have to follow up with that question because I don't know off the top of my head, and it may be different between the US and Canada as well. Do you mind if I just wrap up with the 4 main takeaways before we
Yeah, of course. Go ahead.
yeah. So the 4 takeaways I really want you to take out of this orient around the fact that IP is a preventative measure. So you really need to take steps now. And here are the steps that I want you to take to ensure that you're protecting your copyright in the future. So the first one is include IP clauses in all contracts. I've mentioned this a few times in the presentation. This is the most important thing. You need to own your copyright. If you don't own the copyright, you might not be entitled to use the product or the service that you're developing. And that is so crucial. You do not want to not own the product that you've spent so much time and so much money investing in. The second is publish copyright notices. Make sure people are aware of the copyright that you own, and put them on notice. Warn them that you're ready to enforce your copyright. The third is keep detailed records. Make sure you know who contributed to which products and projects, and when it was created and what versions were developed as you're building the product. And the fourth one is educate your team. Make sure everyone in your company and your service providers as well are aware of copyright issues so that they're not contaminating your product with third-party copyright, and make sure that they're not publicly disclosing things that don't need to be publicly disclosed. Okay. I'll hand it back to you, Rochelle, unless there's any other questions.
Yeah, I'll just give it maybe a few seconds to see if anyone puts their hand up. But thanks so much for joining, everyone. Thanks so much, Jillian, for the engaging presentation. We did pop in the chat that a reminder that a feedback survey will be emailed to you, so please fill that in so that we can continue improving these sessions. And also feel free to register a profile on our Elevate IP portal for any updates. Thanks for joining us today, everyone. Have a great day.